Hi, I'm Tom Spiegel with the Spiegel Law Firm, where we represent people who've been fired or afraid that they might be. I want to talk to you today about something that is an important development in employment law, and that's the issue of clawbacks, executive compensation clawbacks. And this is when a head honcho or somebody high up in a company is accused of some kind of wrongdoing or malfeasance, and you would ordinarily leave the company with some golden parachute, right? We've seen that where, hey, this executive essentially ran the company into the ground, or was in charge of sexual harassment, and they leave and they still get paid tens of millions of dollars. Well, now many employment contract provisions you provide for something called clawbacks, and that is like, hey, you would ordinarily get this golden parachute executive when you leave the company, but not if these things happen. Not if you are subject to a Sarbanes-Oxley claim or SOX claim, which is basically a whistleblower claim based on usually on stock prices. If you some include like sexual harassment. If you yourself are accused of sexual harassment, or if you presided over or responsible for a culture in which these sorts of discrimination and harassment were allowed to continue and in essence damage the company, which of course they can do. And that instance, the company can reach into the executive's pocket and say, you know what, we're going to take a big chunk of that change back, which of course is only fair. So if you're an executive, if you're in a person who's in a category where you might be covered by these, just make sure that you know it's there. If you're that high up, you might be able to negotiate some of those provisions, and in particular to make sure that ideally that you have some kind of due process. Can they just make the accusation and then claw it back? What showing do they have to make? What protections do you have? All things that can be negotiated in your contract. And then, of course, to be aware of them, and I'm sure those watching this video would not do anything otherwise, but make sure you're not tolerating sexual harassment, you're certainly not engaging in it, and that if you see these issues, that you understand that this just isn't a matter for legal to handle. This is something that is in your wheelhouse and you need to get involved in. The good news for employees is that it gives you some more leverage in pursuing a claim against your company. Without a clawback provision, for many companies, it's often covered by insurance. So the insurance company is handling a claim against the company, and nothing ever comes out of the company's pocket, right? Other than paying insurance claims, maybe some of the attorney's fees, but they're not going to pay much. So, the top brass, they just keep doing what they're doing. They turn it over to their lawyers and they go on, and there are no real consequences to be paid. And so it's not impossible, but there are limited opportunities to make change within the organization. Of course, you can file a suit. It can, become public, and those can help put pressure on the company, but not as much as you might think. So it really helps to have these clawback provisions because it gives you the potential for more leverage. Because particularly if you're bringing a claim against a covered executive, then he or she has a real incentive to take this very seriously. They have a real incentive, if you've got a decent claim, if you've got some evidence, to settle, and to settle under terms that are more favorable to you than if this was just an insurance claim. The insurance policy can handle it. I don't care what you pay them. I don't care if you pay them. Good luck with that. The executive is going to be more likely at the table or involved in the decision-making process, and the legal department is too. They're going to be looking at this and saying, hey, this claim, implicates some of these provisions in the clawback, against sexual harassment, or that you've allowed this environment to continue, or if you have ignored whistleblower activity, or if you have allowed this to continue. And so the executive have much more, everybody from the board on down to legal has much more incentive to get in there and get this case resolved. So, and many, many more companies are using it, and in a much broader fashion. So if you're going to be covered by one of these, negotiate it if you can. Know that it's there. If you're bringing a claim, understand that this gives you some leverage over your organization. How would you know if your executive has a clawback provision? If it's a publicly traded company, some of that information might be public, but you can also get that in discovery. If you end up filing a suit, and also, it's something that if you hire an attorney when talking to the company's attorneys, that may come up, and certainly something that you can inquire about. But just know that that's something to be aware of when you're bringing these claims, is finding out if that clawback provision is there and understanding that you do have leverage in your own individual claim. I hope that's helpful, and I wish you the best of luck.